Live.
All right. Good morning, everyone. This is March the 14th, and we are getting going with the House Criminal Law Subcommittee. We have 3 bills in work session for today and 3 for discussion. We're not likely to move on the discussion bills since we may not have a full house today, but we're going to do this order for the work session bills. House Bill 211 from Delegate Attar on straw purchases of firearms, and then House Bill 34 from Delegate Crosby relating to indecent exposure, and then lastly House Bill 437 from Delegate Hill on swatting. We also have 3 bills in subcommittee for discussion from Delegates Pippy and Williams, but we'll get to those. We'll talk about those at the end. So let's go ahead and get started with House Bill 211. This was Delegate Attar's bill that originally came in to make straw purchases of firearms, so selling firearms to prohibited people, a felony instead of a misdemeanor. And the amendment, and Janine, if you can put the requested sponsor amendment up on the screen. The amendment was to instead add the straw purchase of firearms to a list of offenses where an officer can make an arrest without a warrant, but with probable cause. And there's a, yeah, there it is. So it simply adds that offense to a list of other offenses for which you can make an arrest without a warrant, but with probable cause. Does anyone have any questions or discussion on this?
And it strikes the line felony, correct?
What's that?
It strikes the felony part and just puts
Correct,
it on there.
correct. Yeah. And the list of existing things that it's adding to goes as low as offenses like theft under $1,000, but also up to some of the concealed carry and offenses. So there are some firearm things and there are some minor theft things in there. Delegate Arcan.
Yeah, so I would move favorable on the sponsor amendment. And I think the last time, when we went through this last time, Kurt's not here, but I'm pretty sure that he also, once he saw the list of offenses, said he wasn't concerned anymore about the new language. So hopefully we'll all be on the same page. So.
Well, let's go ahead and adopt the amendment. All in favor of the sponsor amendments, raise your hand. All right, so that's everyone. So we're taking the bill as this amendment. Do we have any discussion on the bill with this amendment?
Move favorable.
Okay.
Second.
Okay, so we are now on the bill with that amendment, and there's a motion for a favorable. Everyone who's in favor of the bill as amendment, raise your hand. Any opposed? Okay, great. There goes House Bill 211. Now let's go over to House Bill 34. This is the Crosby bill, and I think Lisa Jordan wants to come in on this one.
Can you say the bill number again?
This is House Bill 34. This is indecent exposure within sight of a minor.
Yeah. I'm not sure if Lisa's going to be able to make it. She did text and said that she sent some material, but that was on.
It says she's connecting, Sandy.
Okay, great. Okay.
And then while she's connecting, Mr. Chair, can I make a comment on the bill?
Sure.
Yeah, so I spoke to the sponsor about it, and I'm not sure what amendments are being offered. I think the issue was definitely the jail time on it. It's not enough jail time to click as an issue for people's clearances, but whether it has to be a felony or not, doesn't really matter to the sponsor, leaving that to the committee itself. But wanting a higher penalty on the jail rule. So I just want to put that out there because I know there was discussion on whether it should be a felony or misdemeanor.
Yeah. Okay. So we had some amendments on this one. There was the MCASA suggestion to do the 4-year gap and the prurient intent. I think that's it. Was there another? Oh, Delegate Anderson was thinking about a amendment to somehow put some mental health referral in here. I did speak to him this morning about whether he still intended to do that amendment, and he did not. So there's that. But again, he's also not here today. Well, so we have the suggestion for this amendment. Janine, are you able to put that one up on the screen?
Yes. This is the one that was in the testimony, right?
There may have been a more recent version emailed.
Okay.
Let me send that to you in case. Yeah, let me forward this to you right now. Sending it to your Gmail. Sent.
Okay, I'll put up what I have.
Nope, that's the Pippi amendment. Look in the chat box. I cut and pasted in there, if that helps. Maybe we can put up on a notepad or something. Well, I'll read it aloud in the meantime, in case anyone's on YouTube. The amendment is to insert some clauses that say this person may not commit the, oh, here we go. So this is what we discussed last week, that was some of the suggestions from the conversation and some input from MCASA. Delegate Eric, your hand is up.
Yeah, I would just say that I'm a fan of the MCASA amendments, so I would move favorable on those.
Okay.
Second.
All right, all in favor of this amendment, raise your hand. Is anyone opposed to this amendment? No. All right, so that's the bill now. It would criminalize indecent exposure in front of a minor with prurient intent over 2 years old and at least 4 years older than the person. And that would subject you to 5 years instead of 3, I believe. Yeah.
And are we comfortable with it being a felony?
It's not a felony, I
No.
think.
It's not. It's
No.
not a felony.
The way we're doing this would not felonize it. No.
Oh, okay. Sorry, just checking.
Move favorable.
Second.
Second.
All right, all in favor of the bill as amendment, raise your hand. Anyone opposed? Great. All right, now we're on to House Bill 347, Delegate Hill. This was the bill about swatting and jamming up a phone line for 911. We had a number of discussions about how to handle this. There was the bill came in as a felony. Sorry, and this one is House Bill 437. So this came in as a felony. So you remember this was one discussion, felony or misdemeanor. The bill also came in originally with a different penalty if there was a injury as a result of the swatting call. And then there was a Senate amendment that was suggested that brought the two, swatting and phone jamming, together in one. But I want to start with a different amendment first. Council Claire has taken a look at this over the weekend. And Janine, do you have this amendment handy? If not, let me email it to you.
I don't believe I do.
Okay, sorry about that. I should have prepared for that. So she has all right, Janine, you have it. She has sent an amendment, and here's the first thing I would flag about this amendment. I think the bill originally came in written to some of the harassment and stalking code, and Claire's amendment rewrites it to the section of code about false reports to law enforcement, I believe. And so she thinks it's more properly housed there. Claire, do you want to explain any further thinking on this while we try and get it up on the screen?
Sure. In looking at the bill further, I realized I don't know why, but the first part of the bill is drafted the subtitle 8, title 3 of the criminal law article that deals with stalking and harassment, of individuals, like a stalker, an individual stalker who's stalking a victim. And I just do not believe that this subject belongs there. I think this belongs in either Title 9, Subtitle 5, or Subtitle 6, both of which deal with false reports to law enforcement. Now, 9501 already is in the bill at the bottom of page 2 and the top of page 3. This is the same statute we dealt with in Delegate Jackson's bill, the so-called Central Park Karen bill. And so in my redraft, I just struck out 3801 and 3804 and kept in 9501 with, and I think this part of the bill is good, which adds that a person may not make, excuse me, a false statement to a law enforcement officer or a public safety answering point. So that would allow, if a person calls 911 and they're just talking to the dispatcher, they're not talking directly to a law enforcement officer, it would add to and kind of clarify that part of the statute. And then just strikes the new, some of the new stuff that's added by the bill as introduced, and just increases the maximum penalty under that statute to 3 years, which would allow for an egregious situation where a person causes an entire SWAT team response or something, that would give the court discretion to impose a higher penalty, depending on the circumstances. So,
So do folks get this? So I just want to be clear about what she's suggesting here. And I have to tell you, I had to sit my brain on this because we were really into the weeds on this bill last week. But Claire's suggesting, I think, a simplification of the subject matter. The bill originally came in and rewrote a few sections of code and attempted to write swatting and phone jamming into the false statement section that Claire was just talking about, as well as the stalking and harassment bit. And it had a series of penalties that it wrote into them. And instead, what Claire is suggesting is we simply clarify that the existing law about false statements to law enforcement should include the 911 call centers or whatever, the public safety answering points. And then rather than getting into the complicated business of what happens, just switch the max penalty on that existing offense from 6 months to 3 years. And I believe it's still a misdemeanor in that case. And then it would just be sort of at the discretion of the prosecutor, whether it was a serious swatting case or a minor one. I have to say, I'm slightly persuaded by this simplification of the subject matter, and it also handles our felony misdemeanor issue in some ways. It also gets at this question about whether the Central Park case, whether the comparable penalty, if it wasn't a hate crime, should be aligned a little bit more.
Move favorable on the amendment.
Delegate Erican.
So I'm not opposed to the amendment. I'll just say I think the reason that it was in the other part of the code at drafting is because it was intended to be part of not just false statements to police, which is kind of a, in my opinion, a lesser crime. But I think what the delegate was trying to get at is that when you attempt to have like armed people show up at someone's house under false pretenses, it's a much more serious crime than a false statement to police is, because the person could end up being killed. And
So
it's
the
goal of that.
I get that part, and I guess this is the tricky thing about what's being suggested by this amendment. This amendment covers that, but it also covers the lesser offense now. And and rather than say there's a 6-month offense and there's a 3-month offense or a 3-year offense, it's just a 3-year offense. And the prosecutors will sort out what's serious and what's not serious rather than writing that into the code.
Right.
So I'm a little bit afraid, though. I mean, like making a false statement to police officers encompasses a lot of things and a lot of people. And I don't know. I mean, you guys tell me more if you think it's just, but I don't know that someone who tells a police officer that a car was green when it was red and they know that they've been dishonest is anywhere near trying to have, an armed paramilitary group show up at someone's house in the middle of the night under false pretenses of the person being armed and dangerous. Like, I just don't know. That's a lot of discretion. And I don't know if everyone on here feels comfortable lumping those together and saying, yes, this person who was dishonest about something small to a police officer or call center is akin to someone attempting to harass, abuse, or kill someone using a SWAT team. I don't think that that's the same and that it should be the same under penalties. I'm not sure this person who was slightly dishonest should be looking potentially, if they made the wrong people upset, up to 3 years in jail. Do you know what I mean? I feel like that's going the opposite direction of kind of the justice reinvestment stuff we've been doing for the last 4 years. Even though it's more simple.
No, I got you. You're worried about moving it up on the 6 months for the lower case. All right, Delegate Bartlett.
Okay, so I get the change. I understand it. And we still have the language of 3804 that's still, existing, where you can't make the repeated phone calls to annoy, abuse, harass, and all that stuff. So that's still there. I totally get what Claire did. That was, in my opinion, nothing short of brilliant to simplify it. The only request that I have, though, is because I was working on 9501. I was trying to put in civil liability in the bill that I had and withdrew. And as I mentioned last week, and maybe Claire, it's already in here, but we did have an amendment for the DV community because we wanted to have an exception carved out for the DV community. So I'd like to, if Claire, if that's not already here, or Mr. Chair, I still want to press that amendment. And I did get it to the sponsor, but I don't know if she's had a chance to put it in yet. And I know the language, so if you want me to just give you that language, I can easily do that. And Mr. Chair, if you're talking or anyone is talking, everybody's on mute.
Yeah.
Sorry, I couldn't see my screen there. Thank you. Yeah, why don't you send along that amendment? I'm trying to see if there's a way to harmonize this this last concern about the 3 years being too harsh on a minor false call versus a serious false call. I mean, ordinarily you'd say this is sort of, there's lots of 3-year, theft under $1,000 or whatever. Most people are not doing the max even on something like that.
They'll be a prohibited person forever. That person can never own a firearm again. Is
B gone? Claire, did you take out 3804B completely?
Yes.
Because that, you did? Okay, because that gave the 6 months. Okay.
Yeah, I mean, I guess we could try and still write it to
I'm sorry, I meant
9501.
9501.
Claire, do you think there's an easy cut here to still write this to 9501, but to put some aggravating factor from the existing bill in to step up the penalty?
Is that the domestic violence issue that was referred to, or are you just talking in general?
Just in general, I'm
Okay.
just thinking about this Arakan dynamic.
So a person who, let's see. I mean, I think
Reasonable expectation to impair, intent to disrupt an emergency response, injury. Those are the 3 things that jump out as in the existing original bill. Serious bodily injury, intent to disrupt emergency response, or reasonably expected to impair. Is that too complicated? I don't know.
well, I mean, what do people want to be subject to a higher penalty? What kind of scenario? A whole SWAT team response, or do you want to focus on personal injury?
Yeah, maybe maybe we'll have to break it down by personal, like intent to harm, intent to physically harm, because that's the part that I think the sponsor was trying to get at, was that people are using this to try to kill people that they're either stalking or upset with or don't like for a variety of reasons, up to and including hate crimes. So if we could break it down and say, if there is an intent to cause bodily harm, then maybe that's what gets the 3 years. And then things that are not intent to cause bodily harm, that are just dishonest, stays at whatever it is right now.
I will just flag, we should also think about on this, the ease or difficulty of proving intent.
Right.
And foresight and knowledge and all that sort of stuff. But
It's definitely harder. Yeah.
Delegate Bartlett, is your hand up to chat?
Well, it wasn't, but I'm going to take advantage of that fact that I left it up. So I just need to make sure I understand what Delegate Erican is saying. Are you saying, because I heard one thing from Mr. Chair and one thing from you, are you saying that you want the lesser offenses to be included? Because right now we jump to the 3-year. And so you want the lesser, because we're taking out the 6 months.
No, I want the way the code is now about the lesser crimes, the just dishonest comments or whatever, that should still stay where it's at the penalty that it's at. And we should craft a separate thing for people who are purposefully trying to cause physical harm to someone, because that's, I think, what swatting really is. It's not just being dishonest to police. It's being dishonest with the goal of causing some kind of physical harm to the person, right? They're calling because they want armed people to show up with false information, thinking that the person's home they're showing up to or the location they're showing up to, that person is a threat to society. So they show up, ready to roll. And so I think the goal is different, right? So if you're just not being honest about how you saw your spouse at home with you and you're just covering for them, that kind of thing is different. I mean, we don't know think about in a domestic violence situation, you're married to somebody, they commit a crime, they do, they ask you to lie for them, you lie to police. Should you be looking for these women or spouses are under an incredible amount of pressure. Should they be looking at being prohibited people forever, this victim of domestic violence? And that's what we're really going to be doing. We're going to be making people who make small lies to police included in people who are actively trying to have someone killed by police. I don't think those two things are the same. And I worry about the unintended consequences of lumping them together and putting 3 years on those people. We're going to be capturing a lot of people that are actually victims of crime themselves. And I don't think that's what we want to do as a committee. I mean, traditionally, that's what we try to avoid doing. So I just wouldn't want to put swatting in with that piece at all. It just isn't the same thing to me. And I don't think that's what the sponsor intended. But I mean, if we're too far into the weeds at this point, we can always try to hold it and get the sponsor to come back and share sort of a real-time response to our ideas. But I would love to just leave the swatting piece in a separate. I think it does fit better in stalking and that kind of harassment and abuse, because that's really what it is. They're trying to hurt you by calling SWAT on you. So that's where
can I just pause for a second and I'm just rereading some of these sections just to get a better handle on this. If you go back and look at the original bill and look at some of the penalties in existing law, 3804, a person may not use telephone facilities or equipment to make an anonymous call that is reasonably expected to annoy, abuse, torment, or harass. That's 3 years in that section of law. And then you jump over to the section Claire's talking about, sticking this all into 9501. A person may not make or cause to be made a statement, report, or complaint that the person knows to be false as a whole or in material part to a law enforcement officer, et cetera, with intent to deceive and to cause an investigation or other action to be taken as a result of the statement, report, or complaint. So this section of code is intended to criminalize. It's not just that you lie to the police, you're trying to lie and have a criminal investigation started against me. And so I think I could live with that being more than 6 months, to be honest. It seems like it's more than, did you hit that car? No, officer, I didn't. This is Haven Shoemaker stole money from me when he in fact did not.
Okay. Yeah, that helps clarify that. a lot, because my worry was, right, people who are in coercive controlling relationships ending up catching extra time for things they literally, they couldn't not do because their partner would hurt them if they didn't do it. So
And it's the same penalty as telephone harassment under what you just said, right? Right, David?
Right.
Yeah.
okay.
I mean, if we don't have to do 3 years, I guess, if that's a thing.
No, I think the 3 years is the reason we needed to do it, because the person that wouldn't trigger their security clearance to be reassessed. So we had,
That was
this?
5 years on the indecent exposure one.
Oh, okay. Thanks. Okay. That clears that up. Okay. Oh, no, I remember the problem with this one. She wanted it to be a felony because people aren't investigating it. That was the problem. It's not being investigated with top priority.
Oh, yeah.
Yeah, that's the problem that
And
she
I,
was
and I
trying to
think,
address.
and my comment on that, and I talked to Mr. Chair about my opinions, I think offline, is that, I understand the concept of like a felony gets taken more seriously and things that don't, but I believe state's attorneys, whether when they're elected and their politics of their counties, figure out like what's their priority. So I'll just say anecdotally, right, to the people in this committee, I believe like sexual assault and rape is pretty high on college campuses around our state, right? But if you go to different counties and you go to their circuit court dockets, how many people are investigating and like doing that? And those are felonies. You know what I mean? So I just really feel like it's about what that individual office and then it's not just the felony, right? It also is what a mayor and county executive find important, right? So even the elected state's attorney does not control the police department and the hire and fire for that police department and what's important to enforce. You can't prosecute what's not on your docket. And so for us to think like making something a felony versus a misdemeanor is going to change sort of like whether it's the county executive or a mayor or the elected state's attorney's method to public safety of their jurisdiction. I just don't think that works. I think it's very whatever county executive or mayor or police chief or state's attorney wants to focus on. And that's just how I view that argument on whether it should be a felony or misdemeanor.
All right. So Delegate Arcand, are you raising your hand to speak?
Yeah, I'll just say, yeah, I mean, I'm not a prosecutor, but we have heard testimony from a lot of prosecutors in multiple jurisdictions, even this year so far, that have said, in practice though, that felonies just, they get the criminal defense unit or the criminal investigative unit on it. That's sort of the way that protocols are set up inside police departments, that if it's a misdemeanor, it stays with the beat cops. And if it's a felony, it gets shifted to the special units that have a lot more funding and stuff like that. And so, and on the rape piece, I agree. I completely agree that I would love to see, rapes get put into like a much more important category and treated more like other felonies are. I think the problem is just, it's so hard to get first women to even come forward in the first place. And it becomes he said, she said, and that just becomes so hard for them to even work a case like that if there's no physical evidence present. So it's really, really those are hard cases, I think, to prosecute in general, at least from the people I know who have been the victims and tried to get them prosecuted. It's just a really hard case. These cases, we would, there'd be like actual physical evidence of somebody calling, voices would be potentially recorded, or they'd be saying it directly to an officer. So we would have, I think, good quality evidence to prosecute if we could just get the officers and, if we could trigger the protocol in most departments that seem to favor felony investigations over misdemeanor investigations. I do think in practice that is occurring in at least some jurisdictions, the ones that we've heard from, for certain it's happening in the city. So I don't know how much swatting is happening in the city though. I mean, I think the sponsor did say she didn't want to release too much data because it's happening, but she doesn't want to encourage copycat behavior, which we know does happen. So So that's just what I would say on that. But I mean, if we want to move it with the 3 years, I think it's certainly better than whatever's happening right now. So I mean, we can always come back and tweak it again next year or the year after that if we're still feeling like they're just not getting prosecuted, but they're still happening all the time.
Yeah, and I appreciate that those comments, Delegate Erican, I do. And I just think I'm just uncomfortable also with the felony just because, you know, with Delegate Jackson's bill, it was not a felony. And I know there were members of the Black Caucus that wanted it to be a felony. And we were like, no. So I just don't feel like this. I feel like we have to see how it rolls out. I agree with you. And then if you want to come back and adjust it, I think that would be good.
So we have this amendment in front of us. Is there a motion?
I'll second
favorable.
Haven's. Yeah, I'll second that. I think now that we know what it's doing and it's not just criminalizing small dishonest comments, I think, you know, this is a good amendment. Thanks, Claire.
All right, all in favor of that amendment, raise your hand. Anyone opposed? No. All right, all in favor of this bill as amended?
Move favorable.
All right. Oh, right. Excuse me. Is there a second?
All right.
Second.
All right. All in favor of the bill, raise your hand. All right. All right. So that's the 3 bills we had on the docket. We have some additional bills. I just wanted to flag. We're not going to do anything since we have members that aren't hearing the initial discussion on these. But Delegate Shoemaker raised the question that we had since we were taking up Crosby's bill on indecent exposure. We also had some from Pippi, House Bill 185 and House Bill 471.
Yeah, and if I could, Mr. Chair, with
Yes.
regard to the House Bill 185, of course, that 471 that you just alluded to is very similar to what we just moved with Crosby's bill. But 185, though, is to address a situation like the Caroline County judge situation that resulted in his, killing himself, I guess, not long ago. So that's visual surveillance of kids' genitalia and that sort of thing. So that's what 185 does, as I understand it.
So I'm looking at the bill right now. It looks like it's got a penalty enhancement in there, where originally, and this is what, Peeping Tom stuff, it sounds like.
Yeah, exactly, that kind of thing.
Yeah, okay, so this is a Peeping Tom bill, and you've got the original
Again, with the
offense.
prurient intent, it's got to have that component.
It's 1 year, and the bill would up it to a felony 10 if it was of a child, a child 4 years younger than the offender. There was also via email, and I don't think we've got Lisa Jordan anymore, but there was via email a amendment that she suggested, which basically was trying to get at this thing about whether the judge's vacation home was clearly included in the language of the bill, because I think there was some concern that courts were interpreting that this had to be in a public accommodation location, like a
Right.
bathroom or something like that. So if we take this up, we can take up that issue. But I throw these on since we're discussing these topics generally, and Delegate Shoemaker raised the addition of these other bills. So I'm just trying to take the temperature of where folks are on some of these. Any thoughts on this first one?
And also, I mean, I don't want to speak for Delegate Pippi and Toto, but you know, he's probably flexible on the penalty component if that gives people too much heartburn or whatever, I'm sure. So I'm just throwing that
Yeah,
out.
well, to be honest,
worth.
you know, just thinking out loud based on what we're doing on some of these others, there's also the possibility that we don't mess with the penalties on this one, but we do address this issue about interpreting the court's restrictions on whether a private vacation home counts for the scope of the bill.
Fair enough.
Delegate Erican, your hand is up.
Yeah, I would just say I like this bill, but you know, we can tweak it to make sure it fits in with the framework of penalties that we've been creating for things like this. I mean, obviously, you know me, I would make everything a felony if it has to do with kids and rape. I would like just felonize it all. But I know other people on this committee probably don't feel comfortable with that. So, you know, if we could find a happy medium where we're showing that doing this, and I think we can find a way to include the private residence. I mean, anytime someone has prurient intent, there really is no doubt in my mind they should be penalized. It doesn't matter if they're recording their own home. If we can prove what they're doing is for sexual gratification and they're using children to do it, we should be punishing them in big time. So.
I'm sorry. Can I get the bill number again? I'm sorry. I'm just trying
It's
to read.
HB 185.
Okay, thank.
All right, so while you sip on that, let's and we're not gonna do anything today. I just want to introduce these subject matter here, and in case we want to do something. The other one was House Bill 471. This is also Delegate Pippi, and I believe this one took this same concept of indecent exposure, but is attempting to clarify that this is a sex offender registry offense. Yeah, that was an additional element that we hadn't put in there.
I'm
Claire,
sorry.
is this one of your
Mr. Chair.
bills?
Mr. Chair, can you slow down a little bit and
Yep.
say to me again, say to me, why is this indifferent than regular indecent exposure?
Sorry, let me go back to the bill on
Because it says lascivious, I can't pronounce
Lascivious.
lascivious. And
Yeah.
what's the difference between, just someone can explain to me the difference.
between lascivious and prurient.
Yeah, this is I
pretty
only
similar.
I didn't do that well on the SAT. It was decent. It wasn't like amazing. I'm just confused. I'm confused about the problem.
Let's ask counsel this question.
Yeah.
Counsel, is there a difference between lascivious and prurient intent?
I would have to look it up in the dictionary, but I think lascivious, prurient is more like you're looking at something, you're curious in a, depraved way. And lascivious is more like you're displaying something in a, depraved isn't the right, lewd, in a lewd way. To me, lascivious means you're kind of displaying yourself in a lewd way, and prurient is more like you're, looking at something, you're curious about something in a lewd way, but I would have to look those up in the dictionary. I could do that real quick.
Yeah, I would just say, if I put my defense attorney hat on, like, you're just gonna rip holes through that in trial. Like, what is that? You know what I mean? And I think it's gonna be hard for you to get a jury to understand what that is. So
Well, my concern is
what's the problem he's trying to solve with the bill? That's also
my concern is, are we consistently using prurient and lascivious on these multiple bills I'm just trying to be consistent in our in our approach.
It's probably in case law. It's probably in case law. I'd have to research it, but let me look it up.
I'm pretty sure it's in Black's Law Dictionary too, but anyway.
Well, I just thinking on the other one we just did, we put prurient but not lascivious. Is that something we should be concerned about?
I doubt it.
Doubt it. Yeah, okay. Are these just all stand-ins for perverted or something like that?
Yeah, pretty much.
Yeah. I guess I think like, I don't know if like, sexual crimes are rampant, and we don't have time or the session, but like, I like to look at the crimes like holistically. And I'm not saying, I'm sure Delegate Pippi's got stuff he's trying to fix with this and it makes sense, but like, how do you incrementally keep people accountable? And what are we changing in the code to wrap people up in a way that makes sense? And not like a piecemealed way.
Here's a question I have for council then, maybe again, is this bill, other than the penalty changes in this Pippi bill, also clarifies sex offender registration. So on the other bill, the Crosby bill about indecent exposure, does that not count as sex offender registration?
So are you talking about?
Well, I guess what I'm trying to say is this. Yeah, the Pippi bill, on line starting on line 19, on 471, HB 471, starting on line 19, it appears to clarify that this offense is a tier 1 sex offender offense. And I'm curious now on House Bill 30. What was it? House Bill
34 alone does not put those offenders on the sex offender registry. Because indeed,
Yeah, they should be.
That's the difference.
They should
Yeah.
definitely
this
be.
bill would put those, if both of these bills pass, then those people covered by House Bill 34 would have to register on the sex offender registry.
Yeah, that seems like a low bar. So yeah, they should definitely be. Parents want to know. I mean, when I move to a new neighborhood, I look up in the system who lives near me, so I can at least be on the lookout if I notice somebody sort of hanging around my house or hanging around my kids and they're playing outside when they don't see me. I still wave and still friendly, but I still like to know so that I can keep an extra eye out. And I started doing that when I was in college. On the back of the door, when I was in college at our house, we lived off campus. I had the pictures of all of the violent sex offenders in the neighborhood so that if they came to the door, and we did have somebody come up when I was sitting in my car one day and put his junk on my car window. So it happens.
But you'd still have to, what I just said is not necessarily true. You'd still have to prove the prurient intent. And by the way, I looked up just in dictionary.com, lascivious and prurient, and they both basically mean the same thing, lewd. I don't know what case law there may be about those. I'd have to do legal research on that. But like if House Bill 34 were to pass,
Mr. Chair, I have another meeting at 11.
Yeah, that's fine. We're not going to
Okay.
vote on this. Okay.
Yeah,
Well,
so this bill would not convert the people convicted under House Bill 34 to the sex offender registry. They would still have to, the prosecution would still have to prove lascivious or prurient intent for somebody to have to register on the sex offender registry.
under House Bill 34, if this other bill does not pass, they could end up on the sex offender registry?
No. If House Bill 471 does not pass, but House Bill 34 passes, those people who do the indecent exposure in the presence of a minor would not end up on the sex offender registry, even if House Bill 471 passes, just committing, if all that is proved is that you indecently expose yourself in the presence of a minor, you would not go onto the sex offender registry unless the prosecution proved you had lascivious or prurient intent.
I see. Well,
Hence
I
the
guess my
need
only
for
other question
471.
then is what the other things are that land you on the sex offender registry and whether we're being consistent. But I'll tell you what, why don't we park this for next time? There you go. That's the topic about the sex offender registry. I think we've handled sort of misdemeanor, felony, and the penalty on this issue. It's really about this sex offender issue. All right, very quickly, let's skip over now to the last bill on the docket. It's Delegate Williams. This was a bill about exigent circumstances and whether you can force a cell phone company or a telephone company essentially to release location information under exigent circumstances. And I think I accidentally gave you the Senate cross file instead of the House bill. Here's the House bill. Sorry, there you go. This is House Bill 1053 from Delegate Williams and Shoemaker. So I'll just say, reviewing the fiscal note, one thing I'll note about this is there is an existing process for getting this information to try and locate someone in law, and there's an exigent circumstances exception currently in law. And I guess what the bill is suggesting is that if you have exigent circumstances, missing person or whatever, and you contact the phone company, they're not required to release the information. But the fiscal note seems to indicate that when someone's life at stake, there hasn't been an incident where they've been denied the information. So I don't know, Delegate Shoemaker, maybe you have additional information on the motive here.
Yeah, I appreciate that, Mr. Chairman, but they could. And yeah, that's the problem. That's why a bunch of states are now enacting versions of this Kelly Smith Act to address that potentiality, I guess. So that's the reason for the bill.
I'm having trouble recalling the hearing on this one. Does anyone recall the Genesis incidents or anything like that for this? If not, it's fine. We can come back.
Delegate Williams in her testimony provided an anecdote, I guess. There's something that happened to a close friend / relative of hers in Prince George's County, I believe. So it does happen.
Oh yeah,
that's why she wanted to take the lead on this thing, and I was glad she did.
That's right.
Yeah,
we had a missing
testimony
person
says it.
suicide from Central Committee member. I can't recall, something like that. Okay, yeah, I remember that now. All right, well, we're not gonna move on any of this new stuff without Kurt and Deb Davis here. So I just wanted to make sure we talked about it. So I guess that is it for today. We got in and out in an hour. Thank you, everybody.